It's time for today's Legal Minute with the Law Office of Cooley, Shrair in Springfield. Today, we're joined by attorney Bob Dambrov. We're talking about this new law, Massachusetts Parental Leave Law. So it's new. What is it all about?
The parental leave law extends to male employees the same benefits that female employees have had for a number of years. Effective this year, April 7th, male employees as well as female employees will be entitled to take up to 8 weeks leave for the birth or adoption of a child or the placement of a child with them by a court order.
Now, does this apply to all employees, or is there a certain area of employees that it applies to?
It only applies to full-time employees of an employer who has at least 6 employees.
Now, let's talk the definition of full-time, because I think a lot of people might not know exactly what it is.
Well, unfortunately, the law doesn't define what full-time means. So the Massachusetts Commission Against Discrimination, commonly known as the MCAD, which enforces this law, has said that you have to look at each individual case and the particular facts and circumstances to determine if the employer treats the employee as a full-time or part-time employee. But generally, employees that work less than 30 hours are not considered to be full-time.
And if you just start your job, you can't start a job then immediately take paternity leave. Is that accurate?
Correct. Employees have to be complete a probationary period of not more than 3 months, and if there's no probationary period, they have to be employed for at least 3 months.
Now, what if my wife and I, what if we work for the same company? Do we both get those 8 weeks?
Not each of you get 8 weeks each. The law says that both employees get a total of 8 weeks in the aggregate.
In this job market, a lot of people are nervous, rightfully so, about losing their jobs. What protections do I have as an employee taking that paternity leave?
You're guaranteed to be returned to your prior job or a similar job with the same benefits and privileges and seniority that you had at the time the leave began. The only exception to that is if employees similar or in the same job have been already laid off, or because of economic reasons or operational reasons of the employer, they may not get their jobs back. However, in those situations, the employee has a preference for employment in some other job that they were qualified for at the time that their leave began.
I think a big question on everyone's minds, paid or unpaid leave, what is everybody going to be getting?
The law says that the employer determines whether it's paid or unpaid.
And the employee, in this situation, I would have to give at least 2 weeks' notice. Is that right?
Yes, 2 weeks' notice of the date they're going to leave and the date they're going to come back. But if that's not possible because of reasons beyond the employee's control, then the law says they only have to give notice as soon as practicable.
What if your employer says you can take much more than 8 weeks? How do your rights change?
The employer can do that, and you're still guaranteed the same rights unless at the beginning of the leave or at the beginning of some extension of the leave, the employer specifically tells you in writing that you will not be guaranteed these rights.
And it always is a good idea to try to get everything in writing, and it's always a good idea to consult a lawyer for matters like this.
Yes, it is.
Always a pleasure chatting with you. Thank you so much. That's your Legal Minute. For more information, call 413-781-0750 or visit CooleyShrair.com.